Okay, guys, in the interest of time and my sanity, what I'm going to do is I've read the entire report and I'm going to jump from page to page, give you the highlighted title, probably read one paragraph, and then jump to the next item. Again, I direct you to the report so that you can read it in its entirety for stuff that I missed. Okay, on page 101, BPD's training on force is severely lacking, leading to officers' systematic constitutional violations. BPD officers are trained in the academy when they initially join the department, and then through mandatory annual in-service training, period. Training at both levels at the academy and through in-service is lacking. As described in more detail in section 3A1 below, BPD's training generally fails to provide officers with sufficient instruction on how to operationalize policies. It lacks the integrated scenario-based training that equips officers with the tactical skills necessary to conduct law enforcement activities in a safe and constitutional manner, including strategies that decrease the need for force. BPD's defensive tactics training teaches officers an erroneous legal standard for excessive force. It separates excessive force into 1, perceived excessive force, 2, intentional excessive force, and 3, unintentional excessive force. This separation between perceived, intentional, and unintentional excessive force has no place under well-established Fourth Amendment standards governing excessive force. An officer's subjective intent is irrelevant for Fourth Amendment purposes. BPD's training on characteristics of an armed person also appears to be ineffective. While instructors teach students that 80% of individuals who show characteristics of an armed person, such as wearing loose or baggy clothing or grabbing the waistband while running, will not be armed, this issue of false positives does not appear to be taught in an effective manner. No scenarios involving false positives are employed in the training that would allow officers to internalize and retain this lesson. Additionally, it is critical to learn how to safely and constitutionally approach and investigate an individual who may be armed in a training on the same subject, sponsored by the Department of Justice and the IACP and held by BPD's Training Center for Law Enforcement Agencies throughout the region. The instructors spend a significant amount of time refreshing students' knowledge of Fourth Amendment law and principles. In that training, the instructor repeatedly reinforced throughout the course that a person who displays one of these characteristics is not necessarily armed. Each characteristic should be one factor in an officer's analysis. It does not appear that BPD's own training on characteristics of an armed person provides officers with such critical guidance. All right, page 103. BPD's lack of oversight of officers' uses of force has contributed to a pattern of excessive force. As a whole, BPD fails to exercise oversight of its officers' uses of force. Of the 2,818 force incidents that BPD recorded in a nearly 6-year period, we reviewed BPD's investigated only 10 incidents for excessive force based on concerns identified through its internal review. Of these 10 incidents, it found only 1 use of force to be excessive. During the same period, 25 officers were sued 4 or more times in cases alleging violations relating to use of force, stops, searches, arrests, or discriminatory policing. The few incidents that the department internally noted as problematic are also striking, considering the many incidents we determined to be unconstitutional. Like that of many departments, BPD's policy sets out different investigative requirements for different levels of force that officers use. BPD officers' use of force is investigated through one of 2 routes. First, for most incidents of force, other than shootings, officers notify their supervising sergeant after using force. The sergeant travels to the site where force was used and conducts an investigation at the scene. The chain of command then reviews the sergeant's investigation and either returns it for further investigation or makes a decision on whether the officer's force was reasonable. The process for these investigations is outlined in a policy that has been in place since 2003. It remained in place until July 2016. Until November 2014, all uses of force other than shootings were to be investigated in this manner by an officer's chain of command. For ease of reference, we refer to these as chain of command investigations. In these chain of command investigations, if BPD investigators or reviewers believe that a use of force may have been unreasonable or out of policy, in order to investigate that concern, a supervisor in the chain of command would have to file an internal complaint of excessive force with Internal Affairs. Internal Affairs would then also separately investigate the complaint through its processes. We found that in practice, internal complaints were exceedingly rare. The data we reviewed indicated that only 10 such complaints had been made during the period of our review. Indeed, one sergeant we spoke with about his force investigations of officers under his command indicated that he would not feel comfortable filing a complaint with Internal Affairs if he suspected an officer under his supervision had used unnecessary or unreasonable force. Instead, he would call his chain of command and inform them of the situation, leaving it to them to make a decision of whether to file a complaint against the officer with Internal Affairs to investigate. Whoopie wow. The second route that an administrative investigation of force may take is reserved for officers' use of deadly force. The process for investigating these deadly force cases changed a number of times during the period of force incidents we reviewed. From the beginning of our period of review in 2010 until early 2014, the second route was reserved for officer-involved shootings which were investigated by officers in BPD's homicide unit. In January 2014, BPD instituted a specialized force investigation team to investigate shootings and other use of force that had the potential to cause serious physical injury or death. The force investigation team functioned only until July 31, 2015, when it was replaced as an interim measure by the homicide unit in 2015, and then by a special investigation response team in September of 2015. The SIRT has the same jurisdiction as the former FIT and currently investigates shootings as well as other serious uses of force. For ease of reference, we refer to these as deadly force investigations. BPD's investigations of less lethal force cases are missing critical elements that are necessary to evaluate the propriety of the force used. In BPD's chain of command investigations, critical information that is necessary to investigate force incidents is routinely missing. Investigators routinely fail to investigate any Investigators routinely fail to interview any civilian witnesses, witnessing officers, the involved officer, and the person against whom force was used. In many cases, there are no witnesses, civilian or officer, interviewed even though witnesses were present on the scene. For example, in one 2014 narcotics arrest at a public housing complex during which a taser was deployed, there were reportedly 20 to 30 civilian witnesses gathered at the site of the arrest, and the officer felt it was necessary to call in additional units for backup to deal with the crowd. However, the force report did not include a single civilian witness statement, although the report states that there were no civilian witnesses who wished to provide a statement. There is no indication of the efforts the officers made in attempting to obtain statements from witnesses. From our interviews, it appears that some people may refuse to speak with officers because of the distrust they have of the police. While BPD's policy on use of force reporting requires that notations of a neighborhood canvass for witnesses must be included, many other reports we reviewed did not include such a notation. Even in the instances where it appeared an investigator spoke with a civilian who had witnessed the incident, investigators did not record the civilian's statement or provide the civilian's account in their own words. Instead, the investigator summarized the civilian statement for the investigative file. If the investigator misses relevant information or misunderstands a civilian statement in any way, or if the investigator biases the civilian statement in any way, whether intentional or not, this cannot be remedied by the chain of commands review. All right, jumping to 108. BPD's deadly force investigations lack critical analysis and information that is necessary to evaluate the threat faced and force used. Like its chain of command investigations, BPD's investigations of officers' use of deadly force, including officer-involved shootings, lack critical information needed to evaluate the propriety of the force, reflect the bias in favor of involved officers, and include unreasonable delays. This is concerning as the intrusiveness of a seizure by means of deadly force is unmatched. The subject's fundamental interest in his own life need not be elaborated upon. The use of deadly force also frustrates the interest of the individual and of society in judicial determination of guilt and punishment. Officers' uses of deadly force must be critically examined to ensure that they conform with the department's policy and law. Even when the use of deadly force is justified, much can be learned by critically examining incidents to improve tactics and lessen the use of such force. In our investigation, we requested investigative files for all deadly force incidents, including all officer-involved shootings between January 1st, 2010 and May 1st, 2016. Troublingly, BPD informed us that they could not locate the investigative files for 20 officer-involved shootings that occurred in that time frame and could provide no explanation for their absence. These included lethal shootings of members of the public, including one lethal shooting, as well as firearm discharges against animals and unintentional discharges. Failing to maintain files of such high-risk incidents is a serious omission, inhibiting effective oversight and eroding public confidence that BPD takes seriously its responsibility to oversee its own use of force. Our review of BPD's deadly force investigations revealed many of the same problems that were present in the chain of command investigations. Transcripts of interviews were routinely excluded, and it appears that they were not created in many cases. Inconsistencies between witness accounts, officer statements, and physical evidence were frequently not investigated. Moreover, documents and evidence that one would expect to see in an administrative investigation of an officer-involved shooting, such as crime scene logs, photographs of the subject or the scene, and crime lab reports, were frequently missing from the investigative files we reviewed. As in the chain of command investigations, we saw evidence that involved officers conferred with other involved and witnessing officers about the incident before speaking with investigators. Investigators also failed to question officers about their conduct before the shooting to ascertain, even if the shooting was lawful, what tactical training or other issues could be identified. BPD has inadequate policies, programs, and training to guide officer interactions with individuals with disabilities or in crisis, and fails to coordinate adequately with other social services providers. BPD's inadequate policies, training, and programs regarding officer interactions with individuals with a disability or in crisis also contribute to the systematic use of excessive force in violation of the Fourth Amendment and the failure to provide reasonable modifications necessary to avoid discrimination in violation of the Americans with Disabilities Act. The vast majority of individuals with mental health disabilities, including substance use disorders or intellectual or developmental disabilities in Baltimore, are working, learning, and living in the community and will live their lives without any involvement with BPD. Some individuals with disabilities, however, are not able to access sufficient home and community-based services to meet their needs, may be unable to avoid crisis, maintaining housing and employment, or for youth to engage with school, leading some to come into contact with law enforcement. According to a 2009 Baltimore City Community Health Survey, 23% of residents reported having unmet mental health needs. The rate was notably higher for black residents, 33.4%, and for all individuals with less than a bachelor's degree in education, 28.6%. This disparity was reflected again in a 2011 Maryland Behavioral Risk Factor Surveillance System study, which found that 19.5% of black residents and 15.1% of white residents reported that their mental health was not good, or 8 or more out of the past 30 days. Law enforcement officers are often the first responders when people with mental health disabilities are experiencing a crisis, and the same is true in Baltimore. It is therefore incumbent upon BPD to provide clear guidance to its officers on how to interact with individuals in crisis, but that guideline is lacking. BPD's crisis intervention practices are inadequate. BPD's crisis intervention policies and procedures are inadequate to safely and lawfully serve individuals in crisis. Based upon our investigations, including our review of use of force files, reports, and training materials, as well as interviews with BPD employees, community members, and service providers, it is clear that BPD officers are not prepared to effectively and safely respond to individuals experiencing crisis. Consequently, BPD officers frequently resort to unreasonable force against individuals in crisis and fail to make reasonable modifications necessary to avoid discriminating against people with disabilities. BPD does not partner effectively with community service providers. Our investigation found that there are existing services in the community that BPD fails to utilize sufficiently, many of which may prevent an individual from experiencing a crisis or may prevent recurring instances of crisis. The City of Baltimore provides a range of services for people with disabilities to which the police should be connecting individuals, including community mental health clinics where individuals can receive mental health and substance use assessments, individual and group therapy, and medication management. Assertive community treatment teams, which are mobile teams of psychiatrists, social workers, nurses, and mental health professionals who provide mental health treatment and support services, and the array of crisis services such as community-based psychiatric crisis intervention and addictions treatment services. These include a telephone crisis hotline, mobile crisis teams, mental health professionals including psychiatrists, social workers, and nurses who can be dispatched to any Baltimore City location to provide immediate assessment, intervention, and treatment, medical detoxification for individuals addicted to substances, and in-house and community case management. Although there appears to be a sufficient array of services to meet the needs of many individuals with disabilities, there does not appear to be sufficient capacity in many of these services to meet the need. Gaps in Baltimore City community mental health service system increase the community's reliance on the police as mental health first responders. If a person with mental health disabilities is not adequately connected to services or is not getting her mental health needs met by the mental health system, she may end up in crisis, and BPD will likely be called to intervene. BPD alone cannot solve the problem of insufficient mental health services or capacity, although BPD's collaboration with the mental health services system could result in greater reliance on the mental health system to serve people in crisis rather than law enforcement. What BPD can control, however, is how effectively it uses the resources that exist within the community. To remedy the ADA violations, BPD should strengthen its crisis intervention policies, training, community partnership, and data collection. In order to prevent further ADA violations, BPD should strengthen its crisis intervention policies, training, community partnership, and data collection practices. BPD must develop and implement policies and procedures for all officers on responding to individuals with mental health disabilities to ensure that officers make reasonable modifications necessary to avoid discrimination. BPD must develop and implement effective training for all officers and dispatchers that focus on identifying individuals with mental health disabilities and effectively responding to individuals with mental health disabilities, including making reasonable modifications and diversion to treatment services. BPD's transport practices create a significant risk of harm. Our investigation revealed significant deficiencies in BPD's transport practices that place detainees who are being transported at significant risk of harm. A lack of video monitoring and data collection surrounding BPD's transport practices prevented us from reaching a conclusive determination regarding a practice of rough rides or constitutional violations in transportation. Nonetheless, we found evidence that BPD's officers routinely fail to safely secure arrestees and transport vans with seatbelts. In multiple instances in the past, this failure has resulted in serious injuries and in some circumstances death. This risk of harm should be remedied. BPD has a history of not securing arrestees. BPD relies on specially outfitted vans to transport detainees from the location of arrest or crisis to the district station, central booking, or the emergency room. BPD's use of these vans has at times been the subject of considerable controversy and has led to some reforms, but those have not been consistently carried through in practice. For example, in 1997, BPD arrested Jeffrey Alston for speeding. According to testimony at a later trial, he was placed into a chokehold by BPD officers during the arrest and thrown unsecured into a transport van. As a result of the treatment and transport, Alston was left quadriplegic. A civil jury found in favor of Mr. Alston, and the city ultimately settled with him for $6 million. Following this incident, BPD issued a general order requiring officers to ensure every individual placed in a van is secured with seat or restraint belts. The police commissioner reaffirmed this requirement in 1999, issuing a memorandum stating that it is the responsibility of the officer to ensure that prisoners transported in prisoner transportation vehicles are secured with a seat belt. Guess that didn't get to the Freddie Gray arresting officers.